For those of you who don't know me, my name is Deborah Oppenheimer. I've been an attorney here at Altitude for going on 17 years now, so I've been doing this a long time. As you can see on your screen, there's a small box on the bottom right-hand side of the screen that shows the video feed, me. And then on the left side of the menu, you should see questions and answers icon, so you can type any of your questions there and we'll try and address those as they come up or at the end, either way. CMCA credits are automatically generated once the webinar hosting site provides an attendance report to our office. And then those credits will be sent via email within about 48 hours following the webinar. The credits are not transferable, so they're direct to the person who signed up for the class. If you have any problems or you have any questions, please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about your CMCA certificates. If you type any questions or technical issues you're having, Sean will respond to those. Heaven forbid you don't want me doing that. So just understand that. All right, let's get started. So first things first, I always want to let everybody know all the different additional resources we have at Altitude. We try and put all kinds of information on our website so that even if you can't get a hold of us, there are some resources there for you to look for your questions. Given this firm's been doing this for over, wow, I think we're probably at 25 or 30 years. There's a lot of information on that site. So please feel free to snoop around the site. And if you can't find something, give us a call. Call Sean, call me, call anybody at the firm, and we'll help you find stuff because there's a lot of stuff there. And sometimes you have to know the right word to search to find it. And we'd be happy to help you with that. So for all of you managers, how many of you really signed up to do everything in this list? Especially that last question. Let's protect the board members and the community from any threat of harm. I think if I had you in a room, there'd be a lot of laughs that this is definitely not what you signed up for when you took on this job as a community manager. And yet now more and more, we're seeing all these kind of things piled on to your plate with your responsibility. As managers, as the community, I think we're seeing more and more violence. We're seeing more and more threats with this pandemic and having more people at home. We've certainly seen a lot less tolerance. People have a very short fuse right now, and we're seeing a lot of things pop up. We're going to try and sort through all the different things that pop up as threats. Obviously, if there's one that comes to mind that I've missed, write it in the question and we'll try and talk about kind of the options and how you guys can answer the board's directions and help the board out while at the same time not taking on the responsibility of protecting that board and the community. So first and foremost, you are not the police. You do not have police authority. You do not have police powers. And while this may seem obvious, I think sometimes our board members forget it. Look, if there's a weapon, if there's a threat of a weapon, just go, not my problem, not my job, and step back. If there are issues, if somebody's bleeding, if there's somebody who's hurt, again, not your job. Step back, call 911. Really, you want to make sure at all points your board is aware of kind of the limitations. Hopefully none of these things ever happen. But again, you need to really explain to the board the limitations of your abilities to help them. If there's somebody standing there threatening you, step back, walk away, tell your board to walk away, go call 911. Don't think it is your job to ever listen to anybody threaten you. If you have somebody threatening someone else, again, call 911. That's something you want to make it very clear at all points in time, not your job. If there's damage, if somebody's destroying things, don't protect the community with yourself. If somebody is damaging the property, if somebody decides to take a baseball bat to some part of the community, walk away. Again, don't put yourself in harm's way and just step back. Obviously, with a fire, I think that's a no-brainer. Just step back and call 911. Obviously, the question is, should you try and help? Colorado has a Good Samaritan Act, and it talks about the way people step in to try and help. And it gives you some protections if you try and help. But if you do too much without the ability to do so, you could cause harm. And so you have to be careful with that. You want to try and help to the best of your ability, and calling 911 is that very first step. And if you have some medical training and you want to try and assist, somebody's hurt, okay, that's fine. But just be very careful that the Good Samaritan Act, while it encourages people to try and help, it is not a complete cover for any kind of liability. If you try and help someone and end up hurting them instead, there is some liability and there's some concern there. So you want to be really careful. Bottom line, most people think HOAs have deep pockets, and there's a good chance HOAs would be named regardless. But first step, always call for help. Second, if you can help something and while you're waiting for the experts, go ahead. So let's look at the kind of types of things that we think about when we're thinking about issues that are popping up. Obviously, threats. They come in all shapes and sizes, and we're gonna go through them one at a time and kind of look at some of the things that we're seeing, some of the things that we've had managers talk to us about the different kinds of threats that occur. We're seeing crimes happening in our community. What do we want to do when that happens? What should we do? What can we do? We have known criminals moving into the community. And then we have some dangerous situations developing within our community. Think about last year when the fires were happening and all the different communities up in the Fort Collins and the Loveland area, and all of those fires heading right for those homes. So we're going to try and talk about the different situations where there's fear for life, fear for your safety, fear for your residents, your community, and kind of the different options that, things that happen. Now, this list is not, and this class is not meant to cover every point in time that the cops are going to be called, because we're not going to go into the situations about necessarily the cops get called on loud parties. Okay, it's a loud party. It's annoying. It's a nuisance, and it may be a covenant violation, but there's really not a threat of harm there. They're really annoying us because it's a loud party. So there's going to be a lot of times where there is a situation where police might get called, but it's not a situation where somebody's in fear for their safety or fear for harm. So we probably won't cover that. So let's look at the threats that we're seeing. Obviously, we're seeing a lot of homeowner threats. Threats about the HOA, threats about their neighbors, maybe to the manager, maybe about the manager, about the board members. I have separated out a homeowner threat from a board member threat, and I'll kind of talk a little bit about why I separate those two, and then outsider threats. So when we start looking at the first one, homeowner threats, what are we talking about? Well, we're talking about the homeowner who sends an email that he's going to get you. What's that mean? And that becomes the big question. When we start seeing threats, sometimes we don't really know what they mean. We don't really know what they're intending. And to some degree, sometimes you're going to have to respond to try and figure out what it is they're actually threatening. Are they threatening that they don't like the HOA, or are they actually threatening harm? It takes a very clear case of threat of harm to get a restraining order. And we'll go over that in another slide, and I'll kind of walk you through the steps if we get to that point. But there are a lot of threats that never rise to that. And that's one of the things that you kind of have to sort through. Are they threatening the HOA? I'm sure you've all seen lots of those emails that go by that say, I'm going to get the board removed. I'm going to make sure that you guys never work again. I'm going to take care of this management company. You guys are awful and horrible, and I'll make sure you never work again. Those kinds of threats are much more acceptable under the law. As a homeowner, I have the right to say to you, the manager, or to the board, I'm going to have this management company removed. Because I have the right to vote, and I have the right to vote for a different board that would remove the management company. That's not a threat of harm. And you have to distinguish between, is it a threat of harm or is it just a threat to try and get you fired? Now, obviously, our paychecks mean something. It pays our bills at home. And so that bothers us when somebody threatens us, but threatens our job. But in the court's eyes, there's nothing wrong with someone telling you they don't like how you do your job, and they're going to have you removed. And so you have to be very careful when you get that email in. Can I distinguish and can I prove, if I had to go to court, that this is a threat to harm me? It's not, I'm going to have you fired, because there's a very big difference in that. And oftentimes when we have cases, the homeowners, by their history, by their actions, really did mean the threat of harm. But when we walk into the courtroom, they try and spin it. And they try and tell the court, no, I just meant I was going to have them fired. I was going to make sure that the board hired somebody different. And so sometimes you have to respond to the email just to narrow down what it is they're claiming and what it is they're saying they're going to do. One of the things also that we often see is a threat to have the covenants removed. I'm going to make sure these are revoked. I'm going to make sure that you can't do anything. Those kinds of threats, they have an absolute right to say. It's a political response. I'm going to make sure the covenants are removed. Most of the time, they have no idea what they're talking about. They have no idea what it's going to take to do that. And there's not much you can do about it. And it's not illegal to threaten to try and remove the covenants or to tell them that they're going to have them removed. Now, obviously, it's a lot different when you say, I'm going to torch this place, or I'm going to burn this place to the ground. You're going to regret what you did. Those kinds of threats are moving very, very quickly into a threat of harm. And when you get those kinds of threats, not only do you want to dial the police, then you want to follow that up with the call to your attorney, because at that point, you may need to get a restraining order. Now, even when you need a restraining order, I'm going to tell you to call the police first, because I want you to make a record of it. Because when you get into court on the restraining order, one of the questions when they do fight back, when the homeowner brings an attorney, is they're going to ask you, were you afraid? And if you say yes, they're going to go, then did you call the cops? Because if you were really afraid, you would have called the cops. And so one of the first things that you need to remember is, if you're getting threats and you think they're serious, the police are the first call and the attorney is the second, because you really want to make a record that this person is threatening to harm you by harming, burning down the community. He's going to harm people. So that's really important. And in addition, by calling the police, you're going to have a clear record of when it happened. So if this guy's making multiple threats like this, you've got this charted and you can show it what's going on. The next kind of thing we're looking at is when the homeowner's threatening the neighbors. Do we care about that? Well, obviously, they're not threatening to hurt us, but they're still maybe threatening to hurt someone. So it still may be that you should be calling the police, because they're threatening they're going to go beat up their neighbor. They're going to go stop that noise and beat the snot out of them, or whatever they're going to claim to you. That still may be an appropriate call to the police to let the police know there's a threat of violence. It doesn't mean necessarily that there's something you need to get involved. Obviously, if they call you and say the neighbor's having a horribly loud party, your response back should be, well, then call the police for the loud noise, and direct them in that response. If they call you and say, I'm going to beat up the neighbor, then you're going to be the one calling the police and reporting the threat. You really want to make sure that you take that kind of constant and consistent course of action whenever there's a threat of harm. One of the things that we often see is there's no connection necessarily to the covenant. Some neighbor drives by another neighbor and one of them perceives it to be done in a threatening fashion. And so they're going to beat him up because he tried to sideswipe me. What should you do in that situation? Again, there's really no covenant connection. And so I think our first response would be, that's a neighbor to neighbor issue. We really don't care, right? But I think your your second response is, if you believe he's going to do it, you believe there's a threat of harm, you should report it to the police. It doesn't have to be 911. It can be the non-emergency number, just to let them know that you've received either a call or an email from someone saying they're going to beat somebody else up. And then again, depending on what the circumstance is, you might be responding back to that neighbor saying, I'm sorry that you believe the neighbor tried to sideswipe you in the car. That's not a covenant violation I can help you with. And respond in that fashion. What you don't want to respond to him is, that's a neighbor, that's between you two, I'm not getting involved. Because even though it might be between neighbors, if there really was a covenant violation, you do have a duty to respond. But when it's a driving issue, that's outside of your realm, that's outside of the covenants, and so you just want to respond, that's not a covenant violation, you'll need to take that up with the police if you believe the driving was a violation of the law. One of the other things that you always want to look at is when you have those two neighbors, and we all have them in every community, you've got those two who are just constantly going right back and forth at each other. If in fact they try and drag you in, you want to direct it to the police and pull yourself back out. This is not my action. This is not about covenants. This is about you two and each other. Direct it to the police and pull yourself kind of out of the middle of that situation. Obviously, when the homeowner threatens you, the manager, versus threatening the HOA, it's a much bigger deal, because now it's your personal safety. And you and I know, and we've all seen this, that when homeowners get mad, they don't think the HOA is going after them. They think you, the manager, is going after them, because that's what they see. They see you taking action against them, and they want to respond back against you. They fail to recognize you're acting on the board's authority. They fail to see that you are just enforcing covenants. They feel they're being picked on, they're being harassed, and sometimes their response is very violent. Again, if in fact they send you some vague email, I recommend responding. What is it you're telling me? What do you want? What do you need? What are you threatening? However you want to word it back to that homeowner, see if you can figure out what it is he's saying. Because if he's really going to threaten you personally and go after you personally, he'll probably respond. And when he puts it back in writing and gets even nastier or more specific, that gives you the proof we need in court to get that restraining order or to get him arrested for harassment. But one way or another, we need to figure it out, what it is he's claiming, what he's attacking, and what he's doing. And unless we can figure it out, him saying, I'm going to get you, I can't go anywhere with that. I can't get a court to help me with that. And I see it all the time. I see that threat. I'm going to get you. What does that mean? It doesn't mean anything in a courtroom. It's not enough to get us over it. Now, if we have physical actions and emails together, that might be enough. So if you've got somebody who's following you around, I had an individual down in Colorado Springs. He was following the manager home every night. He was driving behind her. He would follow her into stores. And he was sending these bizarre, vague emails. Together with all of that information, we went to court and got a restraining order for that homeowner, or for that manager, for that manager against the homeowner, that he couldn't come near her. But you have to know the whole story. And so if in fact you've got those vague emails, contact your lawyer, tell them about the emails, but tell them about the physical conduct and everything else that person is doing as well, because you need to have that whole story. The same thing goes if the threat is against the board member. Is he following the board member? In addition, is the email vague? Have the board member respond. Try and draw him out. What is it this person is threatening? What is going on? You want to make sure that they're threatening more than to just have the management company fired or the board member removed, because I can tell you that is what they will argue in court. So we need more than that. It has to be more specific than that, because obviously it's okay for somebody to want to remove a board member. That's their kind of political ability as a homeowner. It's not okay to want to hurt them, of course. One of the things that often happens when there start to be threats against a board member is they want to know if they can get defamation case against that homeowner. And I will tell you, it's going to be, a hit or miss depending on the facts, but I will tell you that the courts consider board members to be quasi-public officials. And as a quasi-public official, the standard of proof in the defamation case is higher than if they were a private citizen. As a public citizen, the proof required to prove defamation is that the lies were made, that the person knew it was a lie and said it anyway, and that the lie caused damages. It's often very frustrating for board members because all kinds of things are said, and some of them are threatening, and some of them are just nasty. But it's very difficult to get to that level of defamation that we can actually go after the homeowner for what they're saying. So it's something to kind of be aware of. Why did I separate board member threats? Because once the board member makes the threats, regardless of what type of threats they are, your job becomes much more difficult. You work for the board members, however, they have a duty, and they have a duty of loyalty, they have a duty of confidentiality, they have a fiduciary duty to the community. If the threats they're making violate any of those, you need to go to the other board members, you need to go to council, because your job as managers to protect the community, and that board member's threats are now threatening it, you have some issues and you need to work with council to work through how to rein in that board member or get him recalled or get him removed, because your duty always is to the community, not to those individual board members. And I know you work with them a lot, and that relationship makes it very difficult for you to take steps. But if you have a board member who starts making threats, your job changes and becomes much more difficult, because you've now got to take an adversarial role to some degree against that board member. What kind of outsiders are we talking about? Well, and these are probably you're dealing with more often than you think about it. Those renters, they're outsiders. Those renters who threaten you, they don't have any rights of contact to you. Renters have no right to contact the manager. A renter has a right to contact his landlord. The landlord, the owner, has a right to contact the manager. The landlord has the right to contact the board. That renter has no rights to contact you. So when they start threatening you, you can just shut them down. You don't have to talk to them. You don't have to listen to them. You can block their emails. They have no right to talk to you at all. They have no right to attend the board meeting. And so you can kind of ignore them very easily and shut them down. If you believe it's a threat of harm, I recommend you take the same course that you would if it was a homeowner, which is find out what they're really threatening, try and draw them out to get some specifics, and then if it is a threat of harm, turn it into the police, just like you would on a threat from a homeowner. Threats, obviously, I've been talking mostly about emails because I think that's what we see the most, but we see a lot of spoken threats. We also see some physical action. The difference and what becomes important is how do we prove it to the court? Obviously, if you got somebody standing there threatening you, you got your phone and you know how to hit the record button, hit the record button. Record it. One, they will probably stop. They will back off. They might get in your face, but most times when you hit that record button on your phone, they back off because they don't want proof of what they're saying. If, in fact, it's written, you obviously have it. You can turn it into the court. You can turn it into the lawyer. You can turn it into the police. If it's physical, take a picture. You know, if they're following you home, stop the car, take a picture of them in their car. You get in your house, take a picture of them. As you pull in your driveway, take a picture. Get to a place where you're safe and take a picture. You want to show the court that this person is exceeding what's allowed by law. They're stalking you. They're following you around. That's not allowed. Sometimes the physical activity that you see is not following. It's standing over you. Right? Have you ever seen that person who wants to wait till you're seated and then he's going to come stand right beside you and over on top of you just to kind of like threaten you and just hover and make you feel uncomfortable? That kind of thing. Again, that kind of physical contact, physical action on his part, we want to note it so that in fact we can relay it to a court later. And that, you know, taking up that physical and trying to get in your face kind of thing, that's very important to tell the lawyer, to tell the cops that they're using their physical presence to scare you and to threaten you. There's a question, are renters able to vote and come to board meetings if their landlord signed the proxy over to them and state they want the tenant to join the board meeting? Yes. If in fact the renter gets that signed proxy, they get to step in place and come to the board meeting. But that doesn't mean you have to take their emails. Doesn't mean you have to take their calls. If in fact, I mean, we all know that for the most part, most of our board meetings, there's no time and place for any owner to vote. So a proxy to vote means nothing. If in fact that renter is, threatening you by email, threatening you by phone, don't take the call. Tell them to call their landlord. Tell them to call the owner of the property, but you're not dealing with them. So when we're talking about threats, the other way we see threats, not just in the emails, is in text messaging. There are some programs out there, if you're not familiar with them, that you can convert all those texts to a document so that they can be presented in court. Costs about $30. They're not really expensive. And sometimes it becomes a thing that we do need to print out every one of those text messages because when they get on that course and they start texting and they're texting threats and they're texting this and that, we want to capture those so we can take them to court. So if you're getting your threats, if the threats are coming in a text, we want to capture that as well. Enforcement. Again, a lot of this stuff may result in some enforcement, maybe some covenant connection in there. And we don't want to miss that because it'll be used to beat you up later. All right. If in the middle of this is the person who's yelling and screaming is claiming that the reason they're yelling and screaming at you is because you're not enforcing the covenants, we want to have the covenant action by the board like they would in a normal course. So if buried in this email with all this nastiness is a report of a covenant violation, we want to act on that covenant violation. We want to put that portion of this email into the string of our normal covenant enforcement policy. We want to follow up. We want the HOA to act on the covenant enforcement, while at the same time redirecting back to the homeowner that the threats are not tolerable and will not be allowed. Obviously, the police don't care about the covenant violation in the middle of the threats. And sometimes cops are, like everybody else, they have bad days and good days. And if they're a bad day and it's a lazy day and they want to get out of taking action, they may try to avoid their job and say, oh, I'm not enforcing your covenants. And you can go, great, don't bother about the covenant in the middle of this email. I just care about the threats. I've got the covenant. And so you want to separate and be clear to everybody there what you're asking the police to do, which is you want them to act on their authority to protect you or protect the community. You want to make sure that if the covenant is buried in there, some violation, you're going to handle that part. But you want to make sure that you kind of understand whose authority we're looking at, what the authority is about, and how we're going to, proceed on that. Remember, as a manager, you guys know that the HOA, there's going to be, all kinds of fingers pointing. That's why we have insurance, right? If you have one homeowner threatening another homeowner, you don't want to ignore that because heaven forbid the other homeowner gets hurt, they're going to sue the HOA because you knew it was coming and you did nothing. So remember, not only are you acting to protect yourself, to protect others, you're also protecting the HOA by any time there's a threat of harm, you've turned it over to the police who have authority on it. A question, should an email threat of legal action against the board be sent to the attorney? You guys know which homeowners are bluffing most times, which ones are really threatening. If you really believe there's a threat of legal action against the HOA, you definitely want to talk to your lawyer about it and say, hi, is there anything that we're doing that he frowns to attack us on? And work with your counsel to make sure that what you're doing and what is happening is not something that is going to give somebody legitimate grounds to sue you. And once you're comfortable that you're doing it in the correct steps and you're following the law and you're following your covenants and your policies, you can kind of set aside the fact that somebody's threatening to sue you, because you know that we can't stop people from suing us, but as long as we're doing it right, we'll have a defense in court and we're good. So what about the civil protection order? This is, we always used to call them, I'm going to go get a temporary restraining order. I'm going to get a restraining order. They renamed it. It's called a civil protection order. But you have to understand, the only way you can get a civil protection order is if it's a threat of imminent harm. It can't be, I'm going to get you. Court's not going to find there's an imminent threat of harm to somebody with that sentence. It's just not enough. There's got to be, I'm going to beat you up. Okay, clear definition. Said I'm going to hurt you. For who can we get these? Now this is where it gets really tricky and kind of bizarre. If a board member gets the threat, then the board member can go to the attorney and the attorney can help them get a civil protection order. It only protects that one board member. One board member cannot get a civil protection order to protect all board members. A civil protection order is set up to protect one person, only one person. And there's only one exception to that rule. The statute created a threat or a way for employers to obtain protection for all their employees. So an employer would not be an association and a board. There's not a relationship of employer-employee. That's a very specific relationship. Now, take a management company and their manager, that's an employer and an employee. So you could have a management company get a restraining order to protect all their employees if they had threat of harm to their employees. If a manager gets a threat directly to them, the manager can go get a restraining order. The problem being is that needs to be approved. Either the manager needs to work with their boss, to have the boss get their attorney to bring in counsel to get that restraining order for their manager, or the board could vote and say, hi, the manager's only being threatened because of this homeowner, and this homeowner's attacking this manager. We think that the HOA should pay for the manager to get the restraining order. That's fine, but the thing you need to understand is those attorney's fees that are incurred to get that manager a restraining order, even against a homeowner, are not recoverable. There's no fee shift in getting a restraining order for a manager. All right, so you need to be aware of that when you're doing that. Now you'll see in my slide I wrote, attorney is really not needed. Why? Restraining orders were set up for domestic violence victims. The whole statute, all the forms, the whole way it happens are set up to be done by women who are pro se, who are scared to death, and don't have any help. All of the different courtrooms are streamlined to help you through the system. If you ever want to see what the forms look like, we have them in our office. They're pre-printed forms. You check the box. One of the things that you need to be very careful about is there are spots on the box to ask for your address. Don't fill that in. This becomes a public record. You don't want them to know where you live. And there's a box to check to say, I don't want to fill this in because I don't want them coming to my house. If you want them, if they already know where you live because they followed you home, then by all means put your address in there and check the box saying he can't come near your home. But you need to be aware of that. So when there is that threat of harm, when somebody is threatening they're going to hurt you, if they're sending you those emails, they're standing over you, they're following you home, if you're a manager, go to your board. Tell them who's doing it. Tell them how he's doing it. Get the board to vote to have counsel help you get that restraining order, or managers go to your boss and ask your employer to help you get that restraining order. you're going to have to, on that very first appearance at the restraining order hearing, basically testify. You're going to walk into a courtroom and that judge is going to say, why are you afraid? And you have to tell them. And one of the things that happens, and I'm going to pick on you guys here, is when I have men who get threatened, they want that restraining order, but they don't want to say the words, I'm frightened. You have to utter the words. You have to tell the court, I'm afraid this guy's going to come after me. I am afraid. And you have to say those words. And if you're not going to say those words, don't go to court because you're not going to get a restraining order. So you got to say it. You got to walk into the courtroom. You tell them, I'm afraid of him. This is what he does. This is how often he does it. This is when it happens. And if you have clear email saying they're threatening to hurt you, they're going to give you a restraining order. You then have to take that piece of paper, give it to a sheriff, and the sheriff will go serve the guy. You have to go back to court after he's been served to get a permanent protection order. That permanent order, the defendant is in the room sometimes. Sometimes he doesn't bother to show. That's up to him. But if he shows, that's when it's a full-fledged hearing. And that's when you may need an attorney with you. The first appearance, it's pretty straightforward. They're going to walk you through it. You're just going to answer questions to a judge. The second appearance, you may want to have an attorney with you. There's a couple more questions here. What if an owner makes general threats of violence on a phone call? Very angry, agitated, upset, but not necessarily directed to anyone, but mentions being so upset that he wants to go to the mountains and shoot the first person that finds him. Again, I think if you have the ability to record that call, I would record it when they start spouting and rambling and ranting. The fact that he called you would be considered circumstantial evidence that you're in harm's way. If there is, he wants to shoot the first person who finds him, if you have to see him again, meaning there's some way that you know you're going to come into contact with him, then that means that threat of imminent harm is there. So if you've got somebody making those kind of calls about violence, absolutely, I think you want to call the cops on that. And I think you want to look into the fact that trying to get a restraining order. The next question, I'll be looking for you. What you want to do is think in your mind, how could somebody spin out of that? So the defense counsel is going to go, yeah, I want to look for you because I want to talk to you because I'm frustrated with this and I want to talk to you about my problems. It doesn't say I'm going to hurt you. That's the problem with all of these things. You're going to have somebody who's going to try and spin out of it and say, I didn't mean to, I'm not going to harm you. I don't, you know. The other thing is that if it's a threat of harm to the community, you're not going to get a civil protection order. If the comment is, I'm going to torch the building, definitely call the cops because there's a threat and there's people living in the building, but you're not going to get a restraining order on that because it's not a threat to hurt you. It's a threat I'm going to hurt property. And, you know, you're not necessarily going to be able to get a restraining order on that. You know, obviously the threats to beat up are simple. That's the straightforward. Those are the simple ones. You know, I'm going to beat you up. I'm going to punch your lights out. Those are easy, direct, and they're simple to show to a court. He's absolutely threatening to hurt me. I need a restraining order. And let me back up, okay? You guys, many of you who've met me know I used to be a district attorney. A restraining order is a piece of paper. It helps you, and it helps you to know that you can call the cops easier. They're recorded with the cops. The cops can easily research them, pull them up, and find them. But it's a piece of paper. If you got somebody who's trying to beat you up, don't just stand there and wave a piece of paper at him. Leave. Protect yourself first, okay? Going back to the threats, you know, I'm going to take care of you. What's that mean? That's the same as the question that was posed by Mr. Taylor. I'm looking for you. What's it mean? I got to prove to a court that the threat is of imminent harm to you. And if I can't prove imminent harm, I'm not getting a restraining order. We still see a lot of threats, you know, when the developer's in the picture, and we get a lot of threats about, the workmanship and stuff like that. And I've seen a variety of threats against the declarant, against the construction of the community. Certainly what you want to do on those cases is, if you are not the declarant, if construction is over, if this is a situation where it is now the homeowners in control of the community, I want you to respond to the threat about the developer and his threats about how his house was built and whatever else he's threatening. The reason I want you to do that is I want you to put him on notice of a couple things. One, you're not the developer. You don't step into the developer's shoes, and you're not responsible for whatever he did or didn't do. And two, if he has a concern about the construction and how it was built, that's on him to deal with his warranty with the developer himself. The HOA can't help him there. Why do we care? Because when years pass and his warranty expires, you don't want to be sued for not responding and telling him that you're not the developer and you can't help him. While that may have very little basis in the law, you all know that a lawsuit is expensive and your time is expensive, and your wasted time is generally your own personal time. So don't let him waste your time. Try to redirect him at the get-go that the HOA and the developer are not one and the same, and to go talk to the developer, not you. Obviously, if you ever see threats of harm to someone else, it is up to you whether you want to forward those threats of harm to that other person to help warn them. If you really have a threat of harm against the developer, and it threatens to, I'm going to shoot him the next time I see him, I would turn it over to the police, just like any other threat of harm to a board, threat to a neighbor, threat to you. Those kinds of threats, I always recommend just turning over to the police. Again, we talked about disputes involving board members. If the threat of harm is against them, it's the same as you. They can get that restraining order for themselves, but not for their fellow board members. And remember that, again, if it's the board member themselves that are making threats one way or another, you want to reach out to the attorney and get the attorney involved very quickly to make sure that, in fact, they can help you. We also see a lot of threats when it's owner to owner, disputes over parking. How many times have you seen, one person screaming and yelling and threatening someone over a parking? It happens more and more. We're more and more aware of it. We want to be, very quick to, if it starts escalating, call the police. If, in fact, they try and pull you in, again, call the police to pull yourself back out. If, in fact, it's just by emails and there's some covenant violation, address the covenant violation. Try to not address the threats and explain that that's separate and you're not going to deal with that. Involve the police if it's actively happening in front of you. If, in fact, on the dog issues, I don't know if any of you know this, but the very first case after Colorado implemented the Make My Day statute, which was a statute that if you're a homeowner and someone comes to your house, you can use a weapon to defend yourself, but it was over dog poop. We had two neighbors arguing back and forth over dog poop, and one neighbor was mad and took the dog poop over to the other neighbor's house and left it on their front step, at which point he was shot and killed. So I am not trying to make light of any of these, because I, as a DA, saw how these escalate very, very quickly. And again, owner on owner, and you see it's happening, or it's in email. If it starts escalating, I really would recommend that you turn it over to the police. I have a question here. I'm going to move the slide a little bit so I can see it. Have a renter who has pulled the cable wire from their neighbor's unit and has been recorded on the neighbor's camera, who is also a renter. Police were called. Because the police were contacted, do we have any further duty? No. Again, I don't see, unless the HOA is supplying the cable and has some duty to make sure that the cable gets repaired properly. There's probably no covenant involvement there. So the police are there, they're involved, they can deal with it, and let them handle it and try and stay out of it. Owner versus owner, noise, smell, smoke. Again, one of the things that you want to remember is that all of those very quickly escalate, and a lot of times, to some degree, part of the annoyance and part of the frustration and the anger that the homeowners have is because we're saying we can't help them. Many times we have a homeowner who doesn't like smoke, right? He doesn't like smelling it, but there's nothing in our covenants to prohibit smoking. And so we respond back, I'm sorry, there's nothing in the covenants. I can't help you. And with everybody working at home, we're seeing more and more where these owner to owner are escalating. Again, I recommend you call the police. Try and step out of it if you don't have a covenant to enforce. If you have a covenant to enforce, by all means, enforce the covenant. But if they're still going at it, if they're escalating and it's getting to the point where there are threats of harm, you need to involve the police in that. What about self-defense for actual attacks? Obviously, you have a right to protect yourself. That's never changed. I'm of the firm belief that, stepping out of the situation before you need to have self-defense is probably the best way to work that. Sometimes we have some Fair Housing Act complications with some of these threats. Why? Let's look at the first situation, okay? The resident is threatening everyone, right? And he's maybe mental, right? Screaming, yelling. Everybody who goes by, he yells, he threatens, he hollers. And you send a demand that it's got to stop immediately. And you start fining. I have had on more than one occasion an attorney send me a letter telling me that the residents sometimes, and a lot of times the tenants, have a mental problem, and that's what's causing these outbursts. And I can't tell them to stop, and I can't fine them because the Fair Housing prohibits it. And I very, very assuredly tell them they're wrong. The Fair Housing Act only requires you to grant reasonable accommodations. There have been multiple filings in multiple cases in front of the courts that very clearly state it is not reasonable to ask owners to live next to somebody threatening everyone. It is not reasonable for owners to live next to a tenant who threatens people, who bangs on the walls, who screams, who yells, who frightens everyone. That's not reasonable, and we're not required to make that accommodation. And so when you have that person who's going off and then you tell him to stop or to evict the tenant and they send you a letter saying Fair Housing Act, you can't do anything, call your lawyer. And your lawyer can tell them how they're wrong, because that's not a reasonable accommodation that you are required to make. What about a resident that has a dog that bites somebody, and you say, get rid of the dog. We don't allow vicious dogs in this community. And they go, no, 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 I'm disabled and that's my dog and I get to keep it. Again, Fair Housing Act does not require you to allow a vicious dog in the community. If you have a homeowner, and I don't care if it's a seeing eye dog, if it's a seeing eye dog and that dog bites somebody else or is aggressive to somebody else, you can demand its removal. He's allowed to have a dog. He is not allowed to have a dog that bites. That crosses that line. It's not a reasonable accommodation. What about the last one, owner and resident threats that are racial? This is one of those times where you are going to get pulled into a situation that is not a covenant violation, but the Fair Housing Act requires you to step in. If you have one homeowner calling another resident a racial term, a derogatory attack on them because of their disability, an attack on them because of their heritage, Fair Housing Act requires you to do what you can to stop it. So if you have one homeowner and they come to you and they say, my neighbor has sent me horrible letters because I'm Hispanic and you have to do something. I know you would like to say that's a neighbor to neighbor issue, but you cannot say that. You have to do what you can. Now, I know it's limited, but what you need to do in that circumstance is you need to send a letter to the person sending the racial threats. Dear homeowner, that kind of conduct is not allowed in this community. It must cease and desist. I know you got no rule to back it up. You got no covenant to back it up, but you need to send that letter. Then you tell the owner who's being threatened, I've done what I can. Any further action is going to have to be on your part, and here's who you can call to try and help you. I have nothing in my covenants to address the fact that this guy's a jerk and rude and attacking you racially. I've done what I can with a letter, but beyond that, you need to reach out to HUD or CCRD. And CCRD stands for the Colorado Civil Rights Division, because the Fair Housing Act requires that you, the HOA, must do what you can. So doing nothing will get you in trouble. But if you at least try and send that letter and direct the owner who's being threatened where they can get other help, then you've done what you can. What happens at a board meeting? This is something that you guys have to help your board members who may not have the backbone to do it. You guys all have a code of conduct. All of your codes of conduct prohibit screaming, yelling, cussing. You might have a board member who tries to talk somebody down or tries to say, now. You have to tell your board to be strong. Call out a homeowner for violating the code of conduct. Tell him to sit down, no screaming, no yelling, no cussing. If they do it again, you're adjourning the meeting. And if they do it again, adjourn the meeting. Walk out. Then at your next meeting, hold it at the police department. Or hire an off-duty cop to be at the meeting to hold their feet to the fire. The pandemic has given us the greatest ability to deal with these situations because all of you guys as hosts have learned how to mute homeowners. But you know what? As the pandemic ends and we're going to start getting to be able to get together again, these duties are going to come back to us. And we're going to have to be able to take control when you have that screamer. And if he's threatening, you have got to shut down that meeting and walk out the door. But it only works if you get your board to actually walk out the door. One kind of hint that I can tell you is that if in fact you think you might have somebody who's going to be loud and obnoxious, not certain, but he might. The other thought besides the police department is at a church. Most people are much more respectful at a church and much less, boy, that was a terrible sentence, much less likely to scream and yell at a church. And so that will help you try and keep them calm. As we said, outsider threats are those threats from our renters. Most of these threats are threat of suit, not so much threat of harm, but we do have a lot of renters who are going to scream and yell and try and be bullies. And the good news is most of the time homeowners are not going to give them a proxy, and you can exclude them from any meeting. You don't have to take their call, and you don't have to deal with them at all. What do we do about the crimes happening in HOA? These are ones that our residents want us to take action. And I'm going to tell you, and I'm going to recommend to you that you turn it back to the homeowners and tell them they have to take action. All of these situations, if these are happening inside the HOA, these things have to be reported to the police by the person who sees it. Cops don't need your hearsay that Sally told me that she saw whatever. They need to hear from Sally and what she saw, and they need to be able to put Sally's name on their police report because Sally's going to have to be a witness in court. So if you've got crimes happening in your HOA, those have to be reported to the police. They can't come to you. And if you tell homeowners, I am happy if it turns out to be a renter, to send a letter to the renter, to the landlord, that the renter was arrested for any one of these, and the landlord should remove them. Understand, if it's an owner doing this, there's nothing you can do about it. You cannot force somebody to sell their unit, even if they're the drug dealer using their unit to commit crime. Turn it over to the police, but you can't force them to sell a unit just because they're doing this. One of the things that I want to point out here is Anything inside the unit, right? Everybody wants to tell you what they think is happening inside the unit, but cops don't care what they think is happening. Cops need to know what is happening. Do you have confirmed information, right? If you've got Mrs. Kravitz, and for those of you who are too young to know Bewitched, I'm sorry, but Mrs. Kravitz calls the police for everything. She's the little boy who cried wolf. If you constantly have a Mrs. Kravitz calling the police every time somebody knocks on the neighbor's door and she tells the cops that they're a drug dealer, it could be they just have teenagers and they have tons of friends and that's who's coming and going. Don't get lumped into the belief that the cops think that you're overreacting and calling because of nothing. Don't call unless you have an eyewitness standing there to talk to the cop, or you have the email that you can hand to the cop showing the threat. Make sure you have proof of what you think is happening, because if you're just guessing, you're not going to get anywhere and the cop's not going to believe you. Okay, so make sure that you know what you have before you call. All of these are things that the cops could get called on, right? All of these are things that they do come to, but the only thing that really gets their attention most times and what's going to make them race to your site is that threat of violence. So if you got a threat of violence, you got somebody threatening, you got people screaming, you got guns, you got weapons, they're going to be there, and they're going to be in there in a rush because they're going to get all of these types of calls to come to the community, okay? So make sure that when you're involving them, that it's because of a threat. And when they get to your community, understand they don't know what you are. They're going to treat you like a landlord. They may ask you for a key to the unit. They may ask you for permission to search something. You need to educate them when they get to your site, who you are, what your relationship is, and why you called them, okay? So just as a quick aside, they don't get it. Obviously, we've seen some kids who've done the threats. We've seen kids who are harming the community, who are threatening the community. Be careful about that when it is a kid. You need to call the cops. Don't be printing things about young people. Just direct that to the police. If you think a kid is the one who's making the threats, if you think it's a kid who's out there who's damaging or threatening to damage the property, call the police. There are lots of different ways that you can get yourself into trouble, either with familial discrimination, or if you print something that is public and it's about a minor, you can get in all kinds of problems, okay? As tenants, we already talked about that. Again, damage, that's different than threats. And again, live documented threats, call the police. One other things about crime on the community. Recently, we've had multiple communities that have had SWAT called to a community, okay? You're going to get neighbors' questions that are going to ask that you know what's going on and what's happening. Your response to neighbors, direct them back to the police. If there's damage to the unit because of how SWAT acted, you need to follow your policies and start sending letters. You need to then escalate it if nothing's happened. The problem being, and what your board's going to ask is, how do we get them out? And I'm going to tell you, if they own the property, and I don't care if they were arrested by SWAT, I can't force them out. Many times, if it's a tenant, there might be something in the covenants and I can force them out. I can force the landlord to force them out. But if it's an owner, the only thing I can do is, if you've been fining from the day that SWAT hit and the damages to the unit, those fines can keep adding up and we might be able to foreclose, okay? But I can't force them to sell. So be aware of that. The other one that you're seeing a lot is criminals moving in. I can't control, you can't control who buys a unit. Therefore, you can't control if criminals move into your community. And there's no way you're going to know if criminals move in. There are lots of people with felony arrests on their record and they buy homes just like people without felonies. And it's only sex offenders who have to register. So there's nothing that you can do to stop that, and you shouldn't suggest to your board that you can. Many of you have probably read our different articles about what to do if a sex offender does move into your community. We do not recommend you send out a notice. And the reason being is, what happens when you miss one? If you send out a notice when you find out that a sex offender is moving in, but next time you miss one, when you miss one and that one hurts somebody, they're going to hold you responsible. Okay? Be aware of assuming a duty that doesn't exist. If you start telling people and taking on the duty of noticing everything that happens in the community, if you miss anything, you're going to be responsible and they're going to sue you for it. So don't take on a duty that you don't have. You don't have a duty to protect people. You don't have a duty to notify them of other homeowners. Let me get you to the last slide, which is the dangerous situations. Obviously, last year we had a lot of fires up in Fort Collins. We had same down in Colorado Springs 8 years ago. Work with your police. They're going to try and set up ways to help your community know when they can go home, when it's safe, when it's not safe. Use your websites that you have, even use Nextdoor if your community likes to use it. Help yourself to help your homeowner stay out of harm's way as best you can. I apologize, I did go long. If you have some questions, I can stay on a little bit to take those questions. Otherwise, thank you very much and good luck in staying on top of everything that I know you're required to do. Oh, I'm sorry. One of the questions came in, what if we're dealing with threats from a power of attorney for the owner? Depends what the threats are. If they're threats of harm, treat them just like you would a threat from the owner. If it's a threat of damage, same, treat them the same. You do have to respond if he has power of attorney to act on behalf of the owner. I'm an employee of the HOA and we're self-managed. Can my board get a restraining order for me? Yes, if you are technically paid, if you get a W-2, W-4, you are an employee, you're paid an hourly wage, then your boss, the HOA board, could get a restraining order on your behalf if in fact you were threatened. How would I handle a homeowner publishing my home address on Nextdoor? You can't get, I mean, the problem with that is you can't get a restraining order for anybody who could possibly go to your home. Your information is probably out there if you own a home to begin with. If people are smart enough to go to the assessor site, so they're going to know where you live. I don't know that there's anything you can do other than the fact that, you know, be very aware of your surroundings and protect yourself, because there's nothing you can do. It's not illegal to publish that. There's a question about, is marijuana still considered a nuisance? You can try it as a nuisance category. Sometimes that'll work for you, sometimes it won't. It depends on how pervasive the smell is and how many people are willing to say it. When one owner constantly complains about others in her building and no one else has a problem, what do? She's a whiner. That's not a threat of harm. And you can't regulate politeness. You can't deal with, I mean, it's not your job to go in there and teach people manners. Your job is about covenant. If it's not a covenant violation, your response to others is, it's not a covenant violation. Again, when you're complaining about things, can she back it up? If nobody else has that complaint, it sounds like there's no proof, and so you can refuse to do it. Question, when I was talking about kids, do I mean kids as in under 18? Yes. Managers charged with violating nuisance codes. The question is, what about that? what I'm seeing, and this kind of goes back to what I said to you before, cops don't know the difference between what your job is. And we have seen managers who are cited for violating codes as like an owner of a property, and the code enforcement cites the manager for the community not being in compliance with the codes, like Denver codes. If it happens, call your attorney and they will help you. The statute in Denver is bizarre because it talks about managers, and the courts are looking at you much like they would look at a manager who manages an LLC, and they are not understanding your relationship and what it is you do and what authority you have. And the only way to educate them is take it to your attorney and have your attorney help you if in fact you get charged with violating the codes. I think that's all the questions that I have. What do I do if a felon convicted of assault is returning to your community? You can post on your website that if owners are ever concerned about who's living in your community, they can check the sheriff websites, because that's where the registered sex offenders have to register. But push it back to the homeowners to do the checking, so it is not your job. Do not take it on yourself. Sorry. I think that's it. I think that's everything I have, and I know I'm way over time, so thank you all for coming and listening, and everybody have a great day, because it's beautiful outside.